Law Talk with Nick Maruchak. Thanks to MKI Legal, your trusted employment and family lawyers.
I fought the law and the law won. I fought the law and the law won.
And Nick Maruchak from MKI Legal joins us in the studio. He's here to talk to you. So if there's anything on your mind you'd like some advice around, 133 882. Good morning, Nick.
Good morning, Gary.
Everything all right? Everything's set to go?
Yep, ready to go.
Okay, well, I'll tell you what, Jane's there, so we'll go straight to the lines. G'day, Jane.
Yeah, hi guys, how you going?
Good, Jane.
Yeah, I was just calling in to see if you could help me out maybe. A couple of years ago now, I had left a domestic violence relationship and he had put traffic tickets in my name which made me a licence suspended. While I was sorting all that out, the police pulled me over and I was explaining the whole situation and they impounded my vehicle. Mm-hmm. And, sorry, I'm very nervous.
Yeah.
They impounded my vehicle and I was issued a fine. I also received a letter from them asking me to not go for compensation or damages, to sign it and they'll drop the charges. But I didn't really feel right about that, so I wanted to go ahead and go to court. But it wasn't on the court calendar and I'm a bit confused of what to do, because I still have a fine and it's making my licence suspended.
Yeah.
Regarding that stop.
Yeah.
Ooh.
There's a lot going on, Jane.
Yeah, okay.
So you have sent some documents through, and I can see here that there is some. The criminal matter involves charges for driving without authority to drive, and so I understand that when we were charged with that, the police thought your licence was unpaid or suspended, but at the time you were driving, you did have authority to drive. Is that right?
Well, yes, I have authority to drive, but not. Yeah.
Yeah. So
it was in the middle of getting all the tickets removed. I have the letters where all the other fines were removed that weren't mine, which unsuspended my licence, and that came through like a day or so later.
Yeah. So I understand what you sent through earlier was that the police basically didn't update their system at the time. So you were driving, you had the authority to drive, but when they looked up at the system, it didn't update. So then they pressed these charges, and now the police want to withdraw the charges against you because it looks like it was probably incorrectly instituted, but they want to get you to agree not to go after them for compensation. So is that the situation that I understand it, Jane?
Yeah. I was just a bit confused about the whole letter because I didn't think that sort of sat right with me. You know, if I sign that, then they'll drop the charges. They shouldn't have been charged in the first place.
Interesting one.
Yeah.
What does she do there?
So I'm not a
Cut her
criminal.
losses?
Well, see, the thing is, first question I have to ask, Jane, what compensation do you think you can recover from the charges being brought against you incorrectly? Is it?
I'm not sure if compensation is like a complaint, maybe. Just the way the letter reads to me, I just don't think that's right.
Because they're going to withdraw the charges against you. You don't have to fight it in court. You don't have to go through a whole trial. You save a whole bunch of time without going through, a whole year in the court system. So that will save you a lot of grief and a lot of time. And so the question I have is, the only thing they're going to want in exchange for you is not to make financial compensation against them. So in order to make financial compensation, you have to establish losses. So you have to suffer something. So there has to be like a direct link between the charges being brought incorrectly and the losses you've suffered. So if you can't think of any losses that flow from these incorrect charges, it might be because it says here, you will not seek compensation, financial or otherwise, from the WA police if the charges were subsequently withdrawn. So if you haven't suffered any losses except maybe some distress, then it might be worth just signing the letter, getting the charges removed and moving on. That might be something worth considering about. Now, you can speak to a legal aid duty lawyer in the court system. Have you tried to approach legal aid to get some legal advice? Because that will be a really great start.
Over to the police station a couple of times and called the fines enforcement and tried to sort it out, and I wasn't really getting anywhere, and it stresses me out. So then I put it away for 6 months and then go back to it, and I'm at the point where I just want to get it all sorted out.
So this is what I think you do. Call legal aid. Give legal aid a call. They are great in terms of giving access to duty lawyers. These duty lawyers are experienced in the criminal system. They're in front of the court every day. You sit down with them and just discuss with them, look, is this worthwhile signing this document or not? I think it's probably potentially worthwhile, but don't take my word for it. Chat with them first. And see, because it's also difficult to get compensation against the police, right? They have to have some sort of misconduct. It's a bit of a high threshold because the only thing you can get is your legal fees reimbursed if you win the case, right? But if you haven't hired a lawyer, you can't recover that. So call legal aid. I think you're going to the wrong spot. And in terms of your fines being incurred by your ex-husband, you might also have to take steps against him to recover it. And I don't know whether you want to have him back
Legal
in your
aid
life.
yeah, exactly. But legal aid might be able to help with that.
Well, legal aid definitely going to help with this criminal prosecution,
Okay.
but it might be up to you to take civil steps to recover the fines against your husband.
Jane, it sounds like that's your best avenue to sort of decide finally what you're going to do in this one, is just to get that legal opinion from legal aid if they can help you with it. If not, come back to us perhaps next week, but it would be worth you trying that. Appreciate the call. Andrew's there. G'day, Andrew.
G'day, Gary and Nick. How you going?
Good, mate.
I received correspondence from Morris Blackburn. I was a shareholder of Crown when they were having all the troubles they had before the Royal Commission. And Morris Blackburn has launched a class action against Crown. I was in the qualification period. Just wondering, if I sign up to be part of the class action, is there any repercussions on me if the class action doesn't go our way? Can you advise me on that?
So that's the most important thing you want to carefully consider, right? If you lose the case, can Crown come after all the participants in a class action? So so you have to have a look at the engaging documents that Morris Blackburn has set up. So a lot of the time when you have class actions, you have this agreement between a litigation funder. So you have this litigation funder that will put up the money to support the class action, and they will, they'll have a deal with Morris Blackburn. They'll run the case, and if the case wins, the litigation funder will often get a big chunk of the winnings, and then the rest will be distributed between the participants of the class action. A lot of the time, in the engaging documents, the litigation funder will say, we will pay the costs in the event of a loss, right? So you want to have a look at who will be responsible for, in those documents, the costs if the case is lost. If the litigation funder takes the risk, it may be worthwhile participating because, generally speaking, you will have nothing to lose. But unless the litigation funder goes bankrupt or something like that. So you really want to just read those engaging documents and check with Morris Blackburn, and they'll be able to tell you up front, because that's the most important question everyone asks.
All right, is that okay, Andrew?
Yeah, that's good.
Right.
Thanks.
Okay, mate, well done. Helen is there. Hello, Helen.
Hello, good morning. How are you?
Good.
I'll try and keep it as short and sweet as I can. A very dear family friend of ours is in her late 70s, fighting cancer currently. She looks after her elderly sister who has dementia. The neighbours came over last week to advise her that they have taken power of attorney of her sister's assets or what have you, the one with dementia, and not to go through her paperwork because they have all legal documents apparently to show their power of attorney. They're refusing to show power of attorney. First of all, it's very strange that they have become power of attorney. Second of all, in the last 30 days, $65,000 has been withdrawn from her bank account. We don't know where to go from here.
Yes.
How do we find out if they have lodged this power of attorney, which seems very, very strange. But, yeah, to be losing so much money on a daily basis out of her account, we're quite concerned.
So first question is, so the neighbours took power of attorney. That seems, because a power of attorney has to be made by the person, and they have to have mental capacity to make the power of attorney. So if they have dementia, they can no longer make a power of attorney. Do you find it strange that this person would appoint their neighbour into that role? Would there be another family member that would be more suited for the role?
Well, there's only my friend and the lady with dementia, her sister. There's only the two of them. So, they refused to show any paperwork. They said it's all been lodged through a lawyer north of the river, but they won't show her any documentation. But we're quite concerned with the amount of money on a daily basis that's been withdrawn.
Yep. Okay.
Literally in 30 days, $65,000. So
yeah. Well, there is a process for this, thankfully. We do have, in the State Administrative Tribunal, there is legislation, the Guardianship and Administration Act. It governs this. So basically SAT, you go to SAT and you can do a number of things. One is there is a process to request the person who's appointed under the power of attorney to produce records. Because when you're appointed under a power of attorney, you have to act in the best interest of the donee, so the person who you're representing. You can't act for your own best interest, you have to act for theirs, and you have to keep records. So SAT, you can make an application to SAT to ask the person who's acting in that role, the attorney, to produce records. And then you can see where all that money was spent. And if something dodgy happens, if there's no accountability, SAT has the power to remove that person from that position and appoint someone else.
So, in other words, go literally online or call the SAT office. State Administrative Tribunal. Helen, it sounds like you need to...
and I think your concerns are valid. They get 60,000 so quickly.
Yeah, don't waste time. Get onto the State Administrative Tribunal and ask them for advice on what you do next by the sound of that one. If that's okay, Nick, that's that seems to be the thrust of it. Helen, thanks very much for that. We're just up against the clock. It's 13 minutes to 11. Back with your calls after this. Law Talk, but just some sad news. Those two helicopter pilots I referred to earlier on in the program with that crash near Derby, both, according to police, are deceased. Both pilots in two choppers deceased. We'll have more details soon. Let's get back to the lines. Peter, what's your issue with your neighbour, mate?
Occupant, not an owner, at the back decided that he needed the fence more than I did, so he's just excavated the fence the full length, 13 metres. So far he's taken 5 sheets, and it seems to be a loophole in the law. The police, I've had a number of phone calls, been to the police station, not interested. It's a civil matter. The Shire isn't interested, so what am I supposed to do?
Well, with the fence on the boundary, I think he shouldn't have taken the fence. You can't just take the fence. Go to the magistrates. Potentially what you can do is go to the magistrates court and recover the cost, or at least half the cost of the fence at least, or the cost of replacing the fence, potentially under the Dividing Fences Act. Because what he's done is he damaged the fence by removing it, so therefore the fence needs to be replaced, and you go to make an application potentially under Dividing Fences Act, give the magistrates a call, and if he caused the damage, you might be recover more than half. You might be able to get the whole amount to replace the patch.
He doesn't own the property though, does he?
No.
Okay, who's the landlord?
Okay, so you have to go against the landlord because the fence is damaged, and then you have to make a separate claim against potentially this person, right? So I would start with the landlord first and go, look, fence is damaged, needs to be replaced. You caused the damage.
Otherwise, it's going to get ugly.
Look up Dividing Fences Act. It's basically a damaged fence. Normally the cost is split half, but if you can prove that the other side...
Is there a Dividing Fences Act?
Yes.
There you go, the Dividing Fences Act, Peter. Go and have a read of that one first, but it sounds like you need to get to that landlord.
Can't do that. Can't do that. Can't just pick up a fence and take it.
Neil. Hello, Neil. What's up?
Yeah, hi, Gary, Nick. Sent you through an email the day before yesterday.
Got it.
In regards to my daughter, who is going through a separation. I think the letter is pretty self-explanatory in its circumstances. The thing is, the problem is he engaged a lawyer virtually a week after. Who has sent papers through to her saying division of assets and all this sort of stuff. Now, he's retained all of the financial assets plus the vehicle and all this sort of stuff. $164,000 was borrowed against the house she's currently in to build a new house. Now, the fact is there's also documents saying that if she can't refinance her house within 30 days, then she has to sell it. Now, the fact is, if the mortgage hadn't been increased by that amount, they've been paying it for 18 years, so it was down to what she could afford on her modest income.
Right. Okay. Now, Nick's across this in terms of the detail like that. So let's just have a listen to what Nick thinks of this one.
Very quickly, Neil, actually, I'll give you a call as well. I've got your details. I can, give you a more detailed answer. But basically, when you separate, you have to divide the assets in the relation between that both parties own fairly and equitably, right? So don't feel pressure to sign the document that you sent from the lawyer. There are only two ways to make something binding. You either do consent orders or a binding financial agreement called a prenup, right? Any other agreement's not legally binding, so be careful not to sign that too quickly. You want to make sure that division of assets is equitable, right? So if he's earning more income, maybe your daughter might be entitled to a bit more, right? If she's on a lower earning capacity. So I'll give you a call later and talk to you about what I think a fair split is based on their 16-year relationship. And generally, if you can't afford to refinance the house, then the house will ultimately be sold. But let's have a chat more about that. But the law does require a fair and equitable division of assets. They take into account a whole bunch of factors. So we have to first work out whether this split is fair and then what to do about that. So
interesting one. Neil, thanks very much for bringing it forward to us and obviously the detail that you've given us. So Nick's prepared to have a look at that case. Nick, as always, mate, it just races by, doesn't it? The time, it's just gone and all of a sudden it's over.
Yep.
And there you go. We'll do it again next Thursday. Nick Maruchak from MKI Legal. Appreciate you coming in.
Thank you, Harry.
It is now 4 minutes to 11.